طيب بسم الله الرحمن الرحيم الحمد لله رب العالمين اللهم صل على سيدنا محمد وعلى آل سيدنا محمد وصحبه بارك وسلم أما بعد. Respected Chairman and distinguished scholars, ladies and gentlemen, I wish to express my sincere appreciation to the organizers of this conference for providing me this opportunity to present my paper here today. My paper is on the topic of devising, financing, and investment structures for Awqāf, some important issues from an Islamic perspective. I have tried in this paper to review and analyze to some extent the modes for financing Awqāf, which are important from an Islamic legal perspective. I have tried to discuss some Sharia issues that are important in devising, financing, and investment structures for Awqāf, the most important of which pertains to the ownership of Waqf. My paper discusses how these issues become relevant in the financing and investment modes that are popularly adopted currently, and some modes that have been recommended as suitable for financing Awqāf by some contemporary scholarly bodies. In the contemporary scenario of Islamic banking and finance, for various types of financing, different modes and combinations of modes have been used based on equity, such as musharaka and mudaraba, as well as debt-based modes such as ijara, murabaha, salam, and istisla. In addition, combination modes such as musharaka mutanaqisa, ijara muntahiya bit-tamlik, and securitization or issuance of sukuk are also popular. While using these modes for financing and investment projects, it does not give rise to special complications. But the case of Awqāf is different. In the latter, transfer of ownership is not possible in normal circumstances. This demands a special consideration in developing financing and investment modes for Awqāf. Various contemporary scholars have recommended some modes for financing Awqāf, such as musharaka mutanaqisa, istisna, mudaraba certificates or sukuk, shared ownership, and long-term lease, etc. I have stressed on the effect of the distinct position of Waqf with regard to ownership on musharaka or equity-based modes. What becomes important here is the possibility of creating a joint venture based on illiquid assets or urud, that is, commodities, contributed as capital on one or both sides. In the contemporary scenario, such direct contribution in kind is usually upheld based especially on the position of the Maliki school. Other schools of Islamic law more or less require that for establishing a joint venture or on capital in kind, a joint ownership, that is, sharikatul milk, should be created beforehand. However, it should not be ignored that even in the Maliki school, if illiquid assets are contributed as capital in a joint venture, they immediately become jointly owned by both partners by virtue of a sale that takes place concurrently with the contract of partnership. Because of this, Waqf properties do not seem capable of being contributed as capital. Because this would result in a share of the Waqf property entering the ownership of the other party. Therefore, if any equity-based venture is to be created with the involvement of a Waqf, the contribution of the Waqf should be sourced from any income received from the Waqf or from liquid or illiquid assets that belong to the Waqf without forming part of it. Based on the above, I have discussed whether the structure of Musharaka Mutanaqisa or decreasing partnership could be used for financing projects involving Awqāf, which has been recommended by various bodies for the purpose, along with istisna and some other modes. Although this could be used for purchase of assets for the Waqf, it does not appear suitable for developing Awqāf properties. This is because if Waqf assets are contributed as part of the capital, it will give rise to transfer of ownership in partially. Although the share of the Waqf can be ultimately redeemed, this is possible only after the financial institution has become the owner of a part of the contributed Waqf property. Therefore, joint equity-based modes such as Musharaka Mutanaqisa or decreasing partnership, as well as shared ownership, do not appear adequate for the distinct entity of Waqf properties unless if contribution of the Waqf is through other non-Waqf assets or funds that may belong to the Waqf while not being Awqāf themselves. Therefore, compared with equity-based modes, structures based on ijara and istisna appear better suitable. Through istisna projects involving construction of houses, commercial buildings, factories, schools, etc. on Waqf land could be accomplished by agreeing to settle the price over a period of time. The funds for payment could be raised through the revenue generated from the project, through lease of buildings for instance. Most importantly, this mode does not involve a violation of the restrictions placed on Waqf properties. There are some advantages in istisna, such as the upfront fixing of the total price payable by the Waqf that I have discussed in my paper. Therefore, developing instruments for financing Awqaf should involve a careful consideration of the limitations applicable to Waqf properties in Sharia, especially pertaining to its ownership. And lessons can be learned here from the many modes advocated and practiced for financing Awqaf assets throughout Islamic history, which can provide a rich source for further modification and advancement. Thank you very much.